India is a vast country of over 1.3 billion people with a history going back 5 millennia. But perhaps more interesting is the religious diversity of its people. Though a significant majority of Indians are followers of Hinduism, hundreds of millions practice other faiths. One of these religions, Jainism, is the sixth largest, practiced by over 4 million people, though the number is likely higher as many choose to identify as Hindu while still adhering to Jain beliefs. Followers of Jainism are called Jains, derived from the Sanskrit word Jina, meaning victor, and referring to the many saviors who were successful in leaving the cycle of rebirths and have made a path for others to follow. Jains follow an ethical code of conduct with 5 fundamental vows required for both ascetics and Shravaka, or householders. These 5 vows are, first, ahimsa, meaning nonviolence; second, satya, meaning truth; third, asteya, meaning non-stealing; fourth, brahmacharya, meaning chastity; and fifth and last, aparigraha, meaning non-possession. Jains follow the principle of karma, with souls being reborn in various realms of existence according to their past and present actions. One supplemental vow to this ethical code of conduct is Santhara, our main topic of discussion. Santhara, or sallekhana, is the Jain religious practice of voluntarily fasting to death when one feels that one's life has served its purpose. When one believes that they cannot do anything more in their current life to grow spiritually or improve their karmic cycle, they embrace their death. According to the canons of Jainism, or Jain agamas, people that observe Santhara subjugate their passions and remove themselves from worldly material possessions which are considered to be the root of all injury and violence, or himsa. In addition, Santhara is believed to fill the individual practicing Santhara with feelings of complete peace, tranquility, and serenity, resolving any feelings of fear. The person undergoing Santhara must ask for a vow from their teacher. The teacher judges this desire to see if it is authentic or not before bestowing a blessing. Meditation follows this, and then the process of abstaining from solid food, liquids, and finally, water. On average, around 200 Jains practice Santhara to death annually.
The legality of Santhara has received ample international attention in the past few years, after a state court in Rajasthan ruled the ancient religious practice illegal based on how similar it appears to suicide.
This confusion of suicide has to stop. You're using the same word for different phenomena. See, I think what they're trying to say is something. Is that the English law doesn't understand Jain philosophy. The act of translation is inadequate. Second, to take Santhara at its worst just because there are 1 or 2 negative events does not challenge the philosophy, does not challenge the belief system, and it also tries to argue that this community is saying religion is much more complex than a police directive. Santhara is not a law and order problem.
Although Santhara is a religious practice that results in the end of one's life, Jains refuse to equate it with suicide. Jains differentiate suicide and Santhara on the basis of violence. They consider suicide to be an act of violence toward the body. Santhara, on the other hand, is considered the ultimate act of non-violence. Shekhar Hatangadi, a law professor and documentary filmmaker, breaks down this reasoning. Since any kind of eating or drinking would add a burden, however small, to the natural ecology around them, Jains consider zero consumption, i.e. starvation unto death, a la Santhara, to be the high point among the Jain traditions of austerity and self-denial, and therefore the truest real-world act of ahimsa, or non-violence. To family and friends who are close to the deceased, suicide is a tragedy. In contrast, the family of those who practice Santhara are usually content, even festive, when someone passes on. A 2012 episode of National Geographic's series Taboo visits a Jain monastery in Shikopur, a village in northern India. There, a woman named Mataji decided to practice Santhara after she turned 70 and her eyesight and health started failing.
I realized that my body would not function right anymore. So I decided that I had to make my life worthy. The time had come to leave this body.
Mataji took the vow of Santhara in 2000 and reduced her food intake over 12 years. She then gave up solid food. A month afterward, she stopped taking buttermilk and pomegranate juice. Finally, in this ceremony, she takes her last drink of water. In her final days, she is surrounded by Jain nuns as her body weakens. In several instances, she feels that she is on the brink of death. During these moments, fellow Jains who surround her help her into a sitting position.
Wherever you see God in his true form, you never see him sleeping. You always see God in a full sitting position or half-sitting position. No one attains enlightenment while in a sleeping position.
Although Jains called this the most comfortable way to die, Mataji is in visible pain as her body weakens.
They say that you experience this transformation of the soul and experience moments of euphoria, punctuated by, of course, physical pain.
Six days pass before Mataji finally passes away. Her body is carried to her funeral pyre and she is cremated. Instead of mourning, her family and fellow monks and nuns celebrate her death because she has ended her life on her own terms in the best possible way.
The idea of secularism, or the separation of the state from religious institutions, was first introduced by the British during their nearly 200 years of colonial rule up until 1947. The British put in place a secularized judicial system that still recognized certain religious differences, especially between the traditional laws of Islam and Hinduism, the two largest religions in India. India gained independence in 1949, and the preamble to its constitution declares India as a sovereign, socialist, secular, democratic republic. Article 25 of the Indian Constitution gives all persons the freedom of conscience and the right freely to profess, practice, and propagate religion, but also gives the government the right to regulate or restrict any economic, financial, political, or other secular activity which may be associated with religious practice. This clause allows the Supreme Court discretion to determine which religious actions to prohibit on a case-by-case basis. The Supreme Court of India has stated that religious practices or performances of acts that are essential to the pursuance of religious beliefs are as much a part of religion as faith or belief in particular doctrines. However, what is considered to be essential is something that has resulted in much debate during various cases related to religious freedom. Some critics have called into question the true secularism of the Indian legal system and claimed that it is biased towards Hindus, as many of these notable cases have gone against Muslims and other religious minorities and in favor of protecting the religious practices of the Hindus, who make up approximately 80% of the population. Additionally, personal laws covering issues such as marriage, divorce, and inheritance are regulated by separate religious codes as opposed to official secular laws. This reflects the way in which laws were written prior to British colonial rule, but it contrasts with the rest of the attempts to secularize the legal system. There has also been strong pushes by several right-wing Hindu political parties to return to Hindutva, or a collective Hindu national identity in an officially Hindu state. All of this sets the backdrop for the continuing debate on the legality of Santhara and whether or not it should be protected as a religious practice. In her chapter on Rethinking Islamic Legal Ethics in Egypt's Organ Transplant Debate, from the book Muslim Medical Ethics, Shireen Hamdi discusses the intense debate that continues to be held between Egyptian Islamic scholars who have contrasting opinions on the legality of the practice of organ transplantation. Some, like Sheikh Muhammad Mutwali Sharawi, believe that organ transplants should never be allowed because you can't donate an organ that belongs to God, not you. These scholars believe that we cannot decide when we die, and the failure of most organ transplants is proof of God's will that such procedures not be done. Other scholars, such as Sheikh Muhammad Sayyid Tantawi, argue that the issue of organ transplantation is a medical, not a religious one, and therefore, as long as organs are donated to help save the lives of others, as opposed to being sold on the black market for personal profit, the practice should be considered in accordance with Islamic law. This debate is closely related to the legal issues surrounding Santhara, because they both relate to the question of how much legal authority individuals have over what they do with their own body. While the issue of Egyptian organ transplantation has to do with the religious laws in a country that is nearly 95% Muslim on what should be legal for a practicing Muslim to do with their body, Santhara is more of a clash between a ritual not only condoned but encouraged by Jain tradition and by Jain leaders that has been challenged by the legal system of a state in which Jains make up less than 0.5% of the total population. In both cases, however, interaction between religious and legal stances on personal freedom is clear.
The Supreme Court on Monday stayed the order of the Rajasthan High Court declaring the practice of Santhara or sallekhana within the Jain community as legal. The Rajasthan High Court on August 10, 2015 had called the practice punishable under Section 309 of the IPC as an attempt to commit suicide. The High Court also ordered support to Santhara by any person punishable as abatement under Section 306 of the IPC.
Theorist Winifred Sullivan argues in Neutralizing Religion that separation is not possible between secular and not secular, because religion is an all-encompassing experience that extends into social realms. Religious classification, according to Sullivan, is not a constitutional means of creating equality between people, because religion is such a difficult cultural phenomenon to define. To define it and regulate it is essentially discriminatory. Sullivan goes on to address the issues of reforming our ideas of religion, specifically in the US, and says, "The church can solve its problems by keeping away from the government if it has the will. As far as the state is concerned, state action will have to be scrutinized based on neutral criteria like those of the Equal Protection and Due Process Clauses of the 14th Amendment and the Free Speech and Free Association Clauses of the First Amendment." In this manner, Jains have practiced Santhara quietly until recently, when an Indian man's death through Santhara made headlines in 2015 because a state court in Rajasthan deemed it illegal. The court case can be traced back to 2006, when 60-year-old Bimla Devi Bansali announced her Santhara after suffering from terminal brain and liver cancer. Shortly after her death, Nikhil Soni, a lawyer in the Rajasthan court, filed a public interest litigation equating the practice to suicide. Among the Rajasthan court's supporting points was the abuse of Santhara by individuals seeking to expedite relief from needing to support sick and elderly family members. Following protests, the order was reversed by the Indian Supreme Court later that year. The intersection of law and faith is explicitly present in the debate over Santhara and reiterates separation of secular and non-secular as infeasible.
So when you practice these 5 pillars of Jainism, that 5 Mahavratas, when you take a vow on this and you practice the fullest sense, that is Santhara, which you practice, and this is not in violation or against the rights guaranteed under the Constitution of India. Article 25 speaks about practice of religion which does not create disturbance to the public order, morality and health. And Article 21 speaks about your right to life and liberty. So while practicing this Santhara to attain emancipation, which is the ultimate object of Jainism, you do not violate any of these articles guaranteed under the Constitution of India. In fact, if you are not allowed to practice this, they are in violation to your rights guaranteed under the Constitution of India.
Though the practice of Santhara has been contested in the recent past, it appears that it is here to stay. The Indian Constitution ensures its citizens the right to life and religious freedom, and the Supreme Court has ruled in favor of the Jain community, upholding the right to die as a fundamental right if practiced in a religious context.